Test run to start.
ISMC. And now I'm going to look at this one. Professor Messick has a, I'm not saying long, but a distinguished career and in Middle Eastern studies, but also I think in African studies. Primarily in the field of anthropology, specializing in the anthropology of law, and has also written a number of I think volumes and articles and edited volumes that have been appreciated by a scholarly and public audience. And I'm thinking primarily of the calligraphic state from 1993. Also got the Albert Hourani Award, I think, from the Middle East Studies Association. Since then, you have written other books, edited more volumes, more articles, but I think it's important, of course, to say also that we are here to do a book launch on this book, Shari'a Scripts, Historical Anthropology, which I think actually also neatly follows up, and I read through your CV about all the other articles. There is a kind of very nice line of publication, which I think comes fairly close, and I would assume that you're going to talk about perhaps also a little bit, not only about the content, but the context a little bit as well. This book, I'm going to pass it around, but there are also discount forms in the back for those of you who are interested in buying the book. So, warmly welcome to AKU ISMC, and the floor is yours.
Thank you, Leif, and I want to offer my appreciations to AKU Institute for the Study of Muslim Civilizations. I don't know the abbreviations so by heart, but we're very happy to be here, and I'm happy to have some people from Colombia with me and some ambassadors who move back and forth between AKU and Colombia here. And I appreciate all the help to get here today. I want to talk about this book, and I want to give you an overview of it and some of the context, as they've said, for it. But I want to say first a couple of things that that this whole subject of the Sharia is a very vexed subject. I mentioned that I don't have an acknowledgement in this book, but I have a little postscript at the end, script in the title, so postscript at the end, that it has some political observations that are very brief. But it's incumbent upon, I think, scholars to acknowledge or to address the circumstances in which they write about a subject like the Sharia. And you may know, and I think you also here have what we call in the States the Sharia panic. There's a very virulent kind of Islamophobia and racism in the States, and Sharia is meant to be a kind of symbol of all that other that is so evil and a force that's coming at us. And so we have a number of state legislatures in the United States, Oklahoma, Tennessee, many others, have legislated against the supposed possibility of Sharia entering courts in those states. And then there's been marches ever since the new administration. I don't want to mention the president's name. Ever since the new administration, there have been marches. There was a very serious set of marches in 20 cities against the Sharia. And this is a context in which I was writing, and that is aside from the kind of atrocious criminal acts which were made in the name of the Sharia by ISIS and other extremist organizations. So it's a world in which you write that is very contested, but it's the use of Sharia as a symbol for all evil, essentially. And so the other kind of sort of thing I wanted to express in this postscript was the fact of writing about Yemen. Yemen in a time of great suffering and destruction, and to write about it without mentioning the context of the total assault upon that state I'm ashamed of the fact that my country, I'm a citizen of the country that's facilitating those attacks, as opposed to being a stalwart proposer of truce and settlement and negotiation. So that's just a couple of just preliminary context. And I thought I would actually start today by saying a few things about Colombia, because Colombia has a long tradition in the study of the Sharia. I'm just the most recent person to show up on the scene. Do we need all this apparatus on the side here? Yes, okay. Just as an example of the kind of scholarship that's been going on in Colombia for more than a century. This is Richard Goethals' work, a very famous work on the Egyptian Qadis, written in 1908. And he had written even before the turn of the century. And if we move forward, excuse me, we'll move forward shortly. Or we click down there in the corner? No. I should say while we're waiting, there's a new translation of this book about the Al-Kindi book by a French scholar, a very interesting new recent work. Okay, this is a picture of Professor Goethals. In the next 50 years on at Columbia, you have a very famous work, or a couple of very famous books by Joseph Schacht, who was the leading person at mid-century and until his death in 1969. He too was at Columbia, and I've actually benefited from the presence of his students. When I first arrived on the campus, some of the students received me and took me around. I mean, it's a wonderful kind of world in which Islamic law isn't some kind of very strange and distant thing, but something that has been studied at the university by already a half century before even Schacht got there. And then soon after I arrived, my colleague Wael Halak arrived. And this book from 2009 is really the standard in the field these days. And he's written other things. He's written a newer book about the impossible state, he calls it, about the impossibility of an Islamic state in the modern nation-state kind of structural world. And he has a brand new book on a critique of Edward Said's Orientalism, which we're all waiting for. Respectful critique. Anyway, but even the notion of theory and practice that Schacht was so troubled by, and thought of the notion of theory and practice as being a kind of disjuncture, that the theory of the Sharia, the doctrine of the jurisprudence of the Sharia, was really only ideal. It didn't ever get implemented in reality, and that problem has persisted. And you see Schacht, Halak even still mentioning theory and practice, but then also transformations. So that he was dealing with modernity in that book as well. And then, oops, keep going the wrong way. And then my own book, which was mentioned, this book is important for me just to put a sentence to, because it's very different from this new work. This is a book about a transformation, a rupture in the case of Yemen, in which an older kind of Sharia regime with madrasas and older kind of fiqh, doctrinal works, was transformed into new kinds of modern school systems, a nation with a constitution, and legislation of the Sharia, re-legislation of the Sharia. And so that kind of book in its focus on the Ottoman to the nation state is very different from this new book, maybe I'll learn, Sharia Scripts, which is really ends at 1962. It's an effort to study the history of the Sharia in Yemen, which is a very unusual case, very unusual 20th century case, in that it was not colonized in the north, and it was not yet a nation state. So you have all the transformations from colonialism and all the transformations from the nation state had yet to occur. So it's a very interesting example in which the law was fully implemented in terms of jurisdiction and has some other features which we'll come to. Anyway, this book, one of the ways of talking about this book for me is to contrast it with my own work, which was the typical anthropological work on the sort of the remnants of the Sharia in modern societies. And just in case we want to see, this is the current sort of roughly the modern state of Yemen, which joined the old North Yemen, which was Lower and Upper Yemen, to South Yemen, Aden and the Hadramaut areas. And the town I'm going to talk about, that I mostly did my work in, is roughly about here. Oops, and there it is, it shows up. Anyway, this is the town of Ib in the 1970s. It was a walled town. It was a provincial capital. It's about 1,000 years old. Had scholars in it in the 12th and 13th centuries, and we know a lot about the families and the biographical histories of the people and the jurists, especially of this town, and some of the Sufis as well. But you see, it's in a very rugged mountain context. It has wide sort of valleys that extend on either side of it. And now, you know, when you go back to it, as I do, as up until about 2009, before the situation began to deteriorate, it now is a large, much larger town with 2 ring roads. That'll give you a sense. And here's just a view of the old city. You can't. This is one of the new Kuwaiti funded girls' schools. That was the beginning in the 70s of many transformations. And this, I want to talk now just about 2 contexts for the study of the Shari'a in the period that I'm studying, that I work on it, which is mainly early 20th century up until 1962, the revolution of 1962. And the first feature of that, contextual feature, is the nature of the polity. This was not a nation state. This was an imamate. This was an imam. And an imam is a supposedly impossible figure. Joseph Schock told us that the theory of the political theory of the state in Islamic law is a fiction, period. While Halak basically thinks the same thing, that it's an abstraction that never existed in reality. And just I humbly present this figure and 1,000 years of his predecessors as a counterexample to the actual implementation of the chapter in the fiqh, in the law, in the jurisprudence that talks about the imamah. And the key figure of an imam, they're dissent figures, and the Sunnis and Shiites differ on these matters. But the key thing about this kind of an imam is that he's a mujtahid. He's an interpreter of the Sharia. He is capable of being an interpreter of the Sharia. And he's different from other Shi'i imams. This is a Zaydi imam. Different in that in certain kinds of 12 imams, as you know, you have the situation of absence, ghaiba, and also a question of infallibility in other Shi'i imams. Whereas this kind of imam, even in the law books, they talk about the possibility of error of the imam, of corruption on the part of the imam. So you have both very present, boots on the ground kind of leader. Some were weak, some were strong, some were great scholars, some were less so. Their states have a long history. It's 1,000 years. It's not a trivial history. Anyway, this is the first feature of the context for the studying of what the basic study is about texts, about different kinds of texts and how they relate. Just a few more things about the imam. Another sort of modern style figure of question in the jurisprudence and in the institutional structure of the Sharia in Yemen in those days after the Ottomans left was that they retained a kind of appeal court apparatus. But it was an appeal that was really focused on the imam's own interpretive strength and position. This is a court judgment. It's actually the cover of Calligraphic State, in which the diwan of the imam, this is the seal of the imam, just his name. It's not a nation state with another name. It's the name of this imam, Imam Yahya Hamiduddin. And this is the conclusion of that diwan, that group of scholars, that the judgment issued by a judge in Ib was sound. And so you have this appeal mechanism, which, you know, I don't propose to say that the kind of Sharia system I study in early 20th century is some kind of artifact of the ancient past still being enacted. There are lots of details that I do go into about how it's very particular, and the fact of appeal is one of them. Another thing about, though, the imam is that these imams issued what are called choices, ikhtiyarat, and the origins of these choices in actual court problems makes them very interesting for our understanding of the character of the Sharia. And it refutes another common assumption about the courts themselves and the decisions in courts have no relevance to doctrine. In other words, had no precedent value. And I'll come back to this. But these are very short things. They're numbered here. Both the two imams that came with about 10 or 11 choices and then added them according to various kinds of developments by judges in their courts on all sorts of kinds of topics, like a faduli for a child in a time of need. It was a stress period in this imam's reign. There was plague, and how could an individual who's a protector and a sort of fiduciary for a junior, minor, how could there could be transactions? Very detailed parts of the law. We'll come back to this in a minute. And then also just a note in the law books. I mentioned that there is a chapter in the law books, Bab Kitab al-Siyar, which is about the imama. And again, this is often read whether you're reading Mawardi for the Shafis or Sunnis in general, or you're reading others for the Twelvers. It's either that this has never happened or that's impossible because of absence. And here we have in a book called the Book of Flowers, Kitab al-Ashar, a very simple statement that it's the Yajib al-Muslimin shar'an nafsuhu imaman, and it goes on. It's obligatory that they delegate an imam. And again, and they have to be Alawi and Fatimi. And the other important feature is that that person be a mujtahid. Which it's amazing to me in this vast literature we now have on the caliphate. It's mostly about the demise and the non-success of the caliphate. The question of ijtihad, of interpretive capacity, is almost never addressed. It's astounding to me. Anyways, it's a key feature, as is, for example, the notion of being able to delegate. That the imam must be mudabbir, a kind of manager. Where is this? And most of his opinions are accurate, but not all. I mean, this kind of infallibility built into siyasa, into the management of the state. Anyway, I'm still on the subject of one of the two contexts for this study. The second context is equally interesting to me and has to do with property. The other end, if you might say, of the political economy. And you see these terraces here, which the countryside around the town of Ib is it's innumerable terraces, all of sort of irregular shape and going up and down the mountainsides, etc. Each one of these has a name. Each one of it has a sale document or an instrument, or it has an endowment document, and it always will have a lease or ijara, kind of contract for sharecropping or tenancy. And the important point for me contextually is that unlike the Central Middle East, unlike Egypt, where the property regime, the majority property regime, was not a Shari'a category, the property regime elsewhere was things like miri, which is a state form where the payment goes to Beit al-Mal, the treasury, or the sultan. In any case, the person who was the tenant on it is a tenant of the state, essentially, rather than a tenant of a private owner. Because the Sharia has a notion of private property, of milk, of individual ownership, and Yemen is unusual, unlike Egypt, which is predominantly miri in agricultural stuff, and all the Central Ottoman Empire, same way. Here, it's almost exclusively milk. So it's a rare match between the doctrine of property in the law and the practice on the ground. You know, I'm not surprised that Schacht and others said that the Sharia in doctrine and the practice didn't match or didn't fit, because the jurists of the Central Middle East, and people like Zuhair Ghazal, who's written about these kind of things, the jurists were not able to understand the property regime on the ground. Miri was not a category that they could tangle with it, but it wasn't their own category. Whereas in Yemen, a jurist looking at a property conflict was dealing with milk, was dealing with individual property, or waqf, endowment, which has to be built on miri, on milk, or ijara, which is a lease of a private piece of land. Anyway, a couple more images of this property regime. That was the summer in the monsoon season. There's a lot of monsoon season. It's not the monsoon, but the rain has been plentiful. And in the winter, you see this kind of a situation with fallow terraces here on the side, for example. But this is very rough mountain terrain, a little further north in more upper Yemen, in a semi-fortified village. And then this is back in the Ib area, and this is yours truly being an ethnographer and harvesting. And this is the people, after the harvest, after the cutting of this is sorghum, there's a sifting, a winnowing, and then a counting out and a measuring out of the grain harvest, and shares for the landlord, shares for the tenant farmer, for the sharecropper. So now I want to switch now to actually the substance of the analysis of the book a little bit. That is, I've mentioned the political nature of the very special kind of polity, and having mentioned the property regime, which I think is very crucial, I want to pose a couple of questions that I try to answer. One is, what kind of anthropology is this? And this is the kind of anthropology that I advocate for, what I call the anthropologist as a reader. That may not sound too interesting, but in fact, in the history of the discipline, it is a little bit unusual, where a discipline that's oriented towards oral, colloquial understandings, commonsensical understandings, and observation. To be a reader is already to have left the farm, so to speak. You're already doing something that another discipline is supposed to be doing. There are many examples of people who became readers, but it hasn't been thought about methodologically about what that might mean. And so I want to talk a little bit about this kind of humanistic social scientist. In other words, a reader who's both interested in things like philology and to learn from other textual sciences at the same time as he or she is analytic, an analytic kind of reader at the same time. And then the other question I want to talk about some of the methods that might go with that kind of reader. And one of the things I do in the introduction to the book is I talk about it's a brief sketch of the career of Talal Asad, who in my mind exemplifies the transition from an older style of anthropology to a newer style of anthropology, of a person who actually reads, and we see him as a reader, in other words. There's an earlier moment in his career where he is doing other kinds of work, working in Sudan and doing ethnography early in his career. But he talks about the difference between an anthropology, the historian is given an archive, he says, and the anthropologist has to create one. So there isn't a notion of there being an archive, actually, that an anthropologist might frequent. But later in his career, when he actually turns to studying the Shari'a, he becomes an individual who has read texts. So he writes about the advice literature, nasiha literature for the Saudi kings in the late 20th century. And in doing so, he's reading the texts of these critiques and advice documents that come from ulama, from scholars in Saudi Arabia, and he quotes them. And that, to me, is the beginning of what an anthropological reader would look like. It's analytic, but it's also textual. It's interested in text. It's interested, in this case, in a particular genre, nasiha. Anyway, so we can come back to that. But so after there's two contexts, I want to talk about my main categories in this book, and they are very simple ones and very sort of unconventional ones, because I differentiate the texts that exist with the Shari'a as being the library and the archive. And the library refers to doctrinal texts, texts of theory. These are cosmopolitan texts. In other words, they travel, they can be read in other countries. They're not locally specific. They're not historically specific. They don't mention rulers. They don't mention, it's cosmopolitan doctrine that can travel. And this is the library. And one of the ways I talk about the library is that it uses constructs such as fulan, so-and-so. And so as opposed to the library, I talk about the archive. And the archive, as opposed to being cosmopolitan, is relentlessly contingent. And that contingency, it comes down in the use of the proper name. The proper name for people, individuals, places, things, and also dates. So the documents of the archive are dated. And so the contrast between these two kinds of texts, each one consisting of multiple genres, is the main project of this book, to study this textuality. And so I should say that the whole notion of scripts, which I use in the title, is to say I'm actually looking at texts, but it's not the kind of thing that Edward Said talked about as a textual attitude. This isn't that you see these texts and you read the society off these texts. The notion of script is more like a theatrical metaphor, in which there's a difference between a script for a play and its performance. So the script can be, it is itself a work of art. I have a little quote from Tennessee Williams that I like about how the script is just a blueprint for a house that's destroyed or never built. But he's also talking about his own art. And so we would be interested in his script by itself, but he's also interested in the performance, and I think we should be too. And so the archive is, in some sense, the script for the library is, in some sense, the script for the performance of the archive. But at the same time, the archival texts are also scripts for performances in their own right. So it's a sort of a complex metaphor, which I'd be happy to talk more about if you're interested. But let me go through just quickly the genres that I study in both the library and the archive. So you have Fulan versus the name, cosmopolitan versus contingent, traveling texts, Edward Said, versus stay-at-home texts. And also then it's the dialectic between them and how you read for that dialectic. How, for example, does theory enter practice? How does practice enter theory? This is the kind of reciprocal work that I think you need to study any kind of law system. And so I speak of the library and the archive as constituting a textual formation. And these textual formations will be different in different societies, different contexts, different times and places, so that what I'm studying here is an instance. An instance structured by having the imam, having that kind of property relations, but also the particular kind of library-archive relation. So the first stop in the library is the genre of the fiqh itself, the doctrine, which comes in both metan, basic texts, and commentaries. Very interesting relations. So here's, if you're interested in property, you might stop at the contract on sale, which is usually the biggest chapter in a law book, in a jurisprudence law book. It's sort of the unsung hero. Shaks called it the paradigm transaction, paradigm for other contracts, other mu'amalat, but we don't study it much. And if you want to understand the property relations in Yemen, however, you need to study this particular chapter, because this is the contract of alienation of individually owned property, with many other variations. And this is the chapter in the print edition of the Book of Flowers, which comes in the 20th century. And this is a commentary on the Book of Flowers that came in the 20th century, the Gilded Crown in 4 volumes. Commentaries are very expansive. Very interesting relations between text and commentary. Lots of things to say about it, which I won't try to do here. So that's the book world. And there's also, in that book world, I talk about the universe of the interpreter, which has to do with using Quranic verses and particular hadiths, both of which are subsets of the larger Quran and subsets of the larger corpus of hadith. These are the ones that have juridical relevance for rules. The second genre of the library is the fatwa. And this is a mufti in Ibn who's not actually giving a fatwa. He's actually writing something for this young girl who has a wound on her face. But he later gives a fatwa for the imam of the mosque next door about how to give prayers and how to give the call to prayer. And this is the answer he gave to the imam whose name is Hashash, and he has the mosque next door. And the question is posed here, and the answer starts here, and goes upside down and revolves in a direction that I refer to as spiral text in the calligraphic state. And this is a mufti of 2008. The other mufti had died. I saw him just before he died, actually, in a very sad kind of moment where he used to always write when I came in. I'd ask him a question in writing, and then he'd write. He always wrote everything very quickly. And the last time I saw him, he asked me for my pen, and I gave it to him. And he started writing, but his hand didn't move the paper. He wrote on his hand, and the thing became a blot of ink. It was sort of the end of the old writing for me. Anyway, this is a successor mufti who had been a judge, who had been a writer of notarial documents, sitting in his accustomed seat in front of a friend's store. And just like the other muftis, he received questions and answered them on the spot. This is a town mufti. And so there's a whole interest I have in this sort of colloquial mufti versus very high-level muftis. Some of the most important jurists also gave very ordinary fatwas, but they also gave things that became doctrinal sort of arguments. So the fatwa is a second genre. And the third genre, which I don't have an image of to show you, but it's the choices of the imams, which are very interesting doctrinal language addressed in the Fulan kind of discourse, but they come out of, as does the fatwa, as comes out of an archival reality, everyday life reality. So now in the archive, the first stop is with the judge. This is a Sharia court judge sitting in front of his house in Sana'a. And this is the judge, one of the judges I worked with in Ib, who's on the front of the book, just in everyday court, talking to a man who presented himself. And this is one of his guards, very tame man with a cork in the top here, looking very threatening, not at all, but could be dispatched to bring in as a summons to bring somebody in, bring parties in, or to maintain order in the court. And this is the main text we know of for court studies, mostly from the Ottoman Empire, and the Ottomans called it Sijil. A deftar, it's a register, and the most important thing about these registers for the recording of court cases is that they were copies. You can't see it up here, but this is Surat al-Hukm. This is a copy of the judgments. So we have almost no knowledge of the originals of judgments. And they looked, and first of all, the deftar world, people took them home. An office had yet to be constituted. You have the deftars at home stacked up here. And here's the judge again with the cover photo showing you an original hukm, which is a rolled, vertically glued together paper document that can be quite long. And important things about these kinds of judgments is not their material shape, which is very interesting. The important thing is their length. Ottoman court records are the main ways we've known about how the Sharia functions as a court system. And those registers, we don't have the originals, but the registers, the sijil that we do have are summarized, very brief. They do not allow us to know about evidence in any kind of detail. We don't know what the litigants really said in any kind of detail. And the thing of the virtue of these very long Yemeni court records is their incredible detail. Direct quotation, indirect quotation, quoting of documents, testimony, litigant statements. If you want to understand the workings of a court, in fact, this is my newest project about litigation and evidence and truth. This text, this kind of text, which you see the court making decisions about what's significant in quotation. So some people will be quoted directly. If there's an acknowledgement, it's quoted for directly. Other kinds of things less significant are quoted indirectly. He said that, so not direct quotation. Or the next witness said the same thing as the one before. That could happen, not significant. Anyway, the courts, there are two main versions of the register and the original document are the first stop in the archive. And I just want to mention about the archive to reaffirm this point that the Sharia in the past was not the ahwal shakhsiyya, the personal status that it is today. It's personal status in many jurisdictions, Morocco to Egypt and things like that, family court, family kind of matters, when in fact it covered all kinds of property concerns and also all kinds of injuries. So this is a homicide case, a qisas case, qisas shari'i, and this was a normal kind of case, not that there were lots of them, but it was a normal part, it's a part of the jurisprudence, a chapter on injuries, and etc. And I just want to put in here that this is a little tiny subset from just a court judgment, original court judgment. It has a little quotation from the Quran that starts out there, and the word burhan, and meaning evidence, another word for evidence. And this is a little marker of a session end. But anyway, just to say that it was normal to have, if there was a murder case, to have a Sharia court case about that murder. And here's the judge's katib, assistant, scribe, writing out these kind of vertical rolls of a judgment in the judge's sitting room. Now to the other part of the archive I want to talk about is the ordinary documents, the contracts, the wills, the inheritance documents, the endowment instruments. And this is a man who was a good friend of mine, a very wealthy man, who we took this picture so that these are all bundles of contracts, mainly sale documents, but other kinds of things as well. And when he saw this picture at first, this is in the 70s, he was very ashamed of it. It was too immodest. When I came back to visit him in the 1990s, it was blown up on the wall. Things were changing. And here he is back in the days of his youth, when he was an enterprising young businessman, merchant in the town. And anyway, he became extremely wealthy, and he was among the many people who allowed me access to their family documents, their personal documents. And here's one of his good friends, and one of my good friends, one of my landlords, had a collection of family documents, a little older, more 19th century. And we actually sat around and read them together. This is one of the key methods, really, to read with people. Because no matter how well you know Arabic, and mine is skimpy in some kinds of ways, you would always run right past some of the very significant things that are totally obvious. But we sat around and read them, and very entertaining, and I copied them all, of course. And I might note that his son now teaches Arabic at Yale. And this is the kind of documents they were reading. They were bundled up, folded up, and he was reading maybe a different one. But this is a sale instrument. This is a land sale instrument, and an older one. But you see, it starts out with the Shari'a, and you have the Katib's seal here from the old days, etc. It has this spiral form that I talked about. You're upside down in the margins and swirling around. Save my voice here a second. And the other kind of document that is extremely common in the archive is the ijara, which is a lease. This is an ijara of a store, of a hanut. And this is an ijara that is more common, which is the ijara of land. So all those terraces, again, in the countryside and in the valleys, each one has a lease. Unless the owner cultivates it him or herself, it's leased. And these have very interesting features about them that I'll come back to. But this is one of the things, the most important part of it is actually a sharecropping lease. Sharecropping is a very vexed topic in the fact because a sharecropping lease is technically illegal because it's about a future return that's unknown. But in every madhab, every school, the Hanafis, etc., and the Shafi'is and the Zaydis, it was made licit because it's absolutely necessary, sharecropping is. But the characteristic of a sharecrop is that in each year you get, in this case, the robo al-hasab, a quarter of the yield for the landlord. But that future contract for that is what's illegal. And this is the tenant farmer coming down to the town, meeting the landlord perhaps, or doing other things. But there's a whole world in these documents. And in fact, I think these ijaras are probably the most common instrument of all, more so than even marriage, because you have multiple contracts. Every landlord has registers filled with them. And then it also implicates these individuals, the sharecroppers themselves. So the ijara is very fascinating. And this is the notary, one of the notaries in town. This is at home, a little more informal. I have a sort of a formal picture of him like this, but this is more interesting with his son. And he worked throughout the imamate period and actually was a child in the late Ottomans. But I learned a great deal from him. So that's a quick landscape of the library and the archive. And so I want to turn now to some notions of method, some brief remarks about method. And the first one, I'll come back to this in a second. The first one is to respect what anthropologists used to call native theory. For anthropologists, native theory, I'm talking about Boas, I'm talking about Geertz, Levi-Strauss, Bourdieu. Bourdieu said native theory is dangerous because it gets in the way of the analytic sight and the analytic authority of the anthropologist, of the social scientist. But native theory for me is so crucial. Not that you're a believer, you read with the jurist, because in the case of writing, what this book is about, the jurists had thought, they had meta discourse, they had theory about how to write. And they had theory about the problem of writing that had a whole centuries-long arguments about al-amal bil-khat, practice with writing, or writing, the practice with writing, leave it at that. It's sort of difficult to translate. Amal bil-khat, work with, practice, implementation, application with writing. And it's because writing is known to have a downside, especially if you don't have the writer around or the witnesses in the document are not around. What do you do with this text? Can writing stand by itself? And the answer is maybe. It's a very complicated argument which I can't replicate here, but there's obviously could be forgery. There obviously could be additions made to a text that are inappropriate, things omitted from them. There could be unclarities about how the texts are written. So there are many problems with writing. At the same time as writing is, as one of the imams said, is a foundation of civilization. If you don't have contracts and wills and endowment documents and sale instruments and leases, society will crumble and be hostility. But if the writings are bad, if they are corrupt, you also have chaos of all kinds. This is all in the discourse of the jurists about writing, about their own kinds of writing. So that's a very important thing. Native theory, in a sense, is to read with, not push that stuff off the page, but read with it as you try to study how textuality was constituted. Another very interesting problem is doctrinal language, because one of the things you'll notice is that the doctrinal language in a law book like this one will also appear in ordinary contracts. But how do you understand that? The doctrinal language is now altered by the presence of personal names and the presence also of custom. So I'll come to that. So in my basic reading strategy is to read across genres. First of all, to read from library to archive and archive to library, but also within genres. So for example, in the archive, from the court records to the documents that are quoted in the court record. Because they're not all quoted. There are parts of them are quoted in court records. If it's a sale document, for example. And also to juxtapose them. I'll give you some examples of that. And also, I in addition to this kind of adhering to, following carefully, attending to the theorization of writing, for example, there's a kind of textual habitus, an ordinary practice that is not articulated or described or conceptualized, but you can see, as a reader, you can see it being implemented. And one of the features there is orality, because orality is at every juncture. And there are what I call minor institutions, and one of them is dictation, what we call dictation, imla. So you have imla in lesson circles in the madrasa. You have imla in the Quranic text that is the mandate for writing a notarial document. It says that the debtor must dictate, using that word imla. This is dictation. Sounds you give it too much. You misunderstand what it is just by using the English word. But it's an oralization of a text that the person wants to have written, and it dictates to the notary who's going to write. And it's a very important movement, because the text will be misunderstood or not adequately understood or colloquially expressed by the person who is engaging in the transaction, but it's expressed orally, and then it goes into writing, but it doesn't just go into writing verbatim. It goes into writing in the shurut, in the stipulations of a proper contract. So it's transformed in the process. So these synapses of oral to writing, which are many. Another example is the witness in court, after he or she gives us a statement, which is written into the court record in some part, we'll hear a dictation back of what is recorded. And if the person spoke in colloquial and it was recorded in classical, would the witness understand? These are questions we can ask. Or if what the witness said was summarized, would the witness acknowledge what that summarization was? And these synapses are not so obvious. Okay, so, and then the basic structure of the book in terms of method is about composition. To take composition is not simply a snap, but a process. And so quotation becomes extremely important, to pause over quotation in a doctrinal text or quotation in a court record. Very, very important. Okay, so let me give you some examples very quickly here. A couple of examples of readings. And this is a Shafi'i law manual from this town of Ib, which was both Shafi'i in terms of its own madhab of the area, and Zaydi in terms of the polity that was ruling it during the first half of the 20th century. And this is a law book, a fiqh manual in verse, written by Ibn Raslan, Palestinian, and it's another chapter on sale, again, in verse. But the thing I want to point out here is the marginalia. Marginalia is totally interesting as for the questions of reading and textuality. Not only is it a comment, and there's also things like ta'liq, which is sort of in the margins, and then there are also full commentaries of the text like this. So at least three genres of additions and extensions of an ordinary fiqh manual. And you see the interesting sort of stuff. The margins were left in the book for the addition of these anticipated additions, and they're upside down, these two, this one at least, and this one. So one of the things to study marginalia is to study the temporality of a text, because these were added later, and maybe not by the same person. But these are questions of somebody who has read the text and has written further. So you're both in questions of spatiality, spatial organizations of text, not spirals, but something else. And then you're also interested in the temporality of the text, which has grown or been transformed or been augmented or commented upon in some kind of way by marginalia in this case. And that's fairly common way of thinking about it, actually, that you're thinking about temporality and spatial organization. But then you can also look at the archive for the same thing. This is now annotation. This isn't marginalia. It's different genres. It's not about sharh or hawashi or ta'liq, all these kind of doctrinal kinds of textual forms. This is about annotation of various kinds. This is another sale contract, land sale contract. And after the notarial signature here, and this comment that he wrote himself, the notary did, there is an ihtimad here by an official or a judge or a mufti, and that person's signature, and its own basmala, and actually was by the judge, Hakim who's signing it here. So this is a different moment in this text's history, and it implies again another readership of the text below, and further writing. And this is an authentication, again by a judge of Ibn in this case. This is an entry point saying that a copy of this text was entered in a deftar, a special deftar of the court for transactions, mu'amalat. And so what you find in this, again, a later edition, temporality is involved. It also involves the movement of this text itself, because you didn't just get this at the office. You were at home with a notary writing this text, and then after you finish that, you go to this guy, the judge, for authentication, ihtimad, tasdiq, many names, and then you go to maybe elsewhere, because maybe you saw the judge at home, go elsewhere to wherever the court secretary is, there's not an office, to get this entry of the copy in the deftar. So this is a sign of the copy and the page number, etc. And then this is a further transfer of the contents of the document. If a further sale occurred of the same property, you'd have this annotation. So you have annotations that, again, temporality, spatial organization, signs of readership, and new writing. So you can compare marginalia and annotation. Another kind of reading strategy is the use of models. And so models, in general, the archive the library is an archive for, the library is models, provides models for the archive in general, but there are also very specific models. And this is what's called a shurut manual, which is a model for how to write notarial instruments. It has very interesting, I wrote a whole chapter just on the introduction and conclusion to this text, because it's so fascinating about the art of writing, the science of writing, and it's all about the corruption of some writers and the uprightness of other writers. But if you actually look at the actual models, which is another chapter, this again is the chapter on sale, you see it identified here in the margins, and here it is. And this chapter 4 of the shurut manual is on sales. If somebody, a shakhs from another person, an individual bought from another individual a house or a piece of land, or etc., then the writer writes, Ashtara fulan. This is that quintessential, in my view, doctrinal discourse of impersonality. It's a model as opposed to it has no dated, it's not dated, it's not signed, it has no basmala, and it uses the word fulan, for example. And so you have a model for how a sale contract of the kind I've been showing you should be written. And the strategy here is to compare and juxtapose the model with actual records, actual sale documents. Now, people like Wael Halak have written a lot about shurut manuals, and many other people have written about Shakdid, about shurut manuals, but they didn't have an archive to go with them. So what they speculated about practice in this kind of a study, which can juxtapose the model with the model, is a way to understand better both the model, what's a model, and the archive itself. And so you end up finding a couple of things. You find this standard doctrinal language, some of it replicated, like ijab al-khubur, which is standard Sharia contract language, is here. But a lot of all the names, it's filled with the names again of the individuals. It's all about the proper name. The name of the individuals, the transactors, the name of the property, the amounts of money, all these things which are left in the Fulan kind of register in the model. And then also you have a little bit of talk, I know you can't see this, but I don't know if I can find it here either myself, but it says everything that's licit, shar'an wa urfan. In other words, in Sharia and in custom. Custom doesn't register too much in this kind of a document, except in the name, for example. The whole document is called the Basira, which is Yemen, Yemeni colloquial genre name. So anyway, this is when you get into the Ijara contracts, however, there's a lot of urf, there's a lot of customary stipulations. Half of the documents of the actual archive are customary stipulations about how you have to deliver the proceeds to the landlord's house, how you have to do a kind of personal corvée at his house, all these kind of things. And even the notion of robo al-hasl, the quarter of the return, is totally customary and totally illegal by the model view. Anyway, you can begin to talk about these things. A third example of this kind of analysis that's across the library and the archive is an analysis based on a very simple thing, which is a ubiquitous term in the whole Islamic tradition, which is a mas'ala, a problem, an issue, a case, a topic. And in the case of the law, a mas'ala is a fact situation and a rule. Or even ethnographically, a fact situation that doesn't yet have a rule, that hasn't been given an interpretation. So I would see people on the streets arguing, and their whole kind of issue about what was going on was stated in very, amateur terms or sometimes professional terms about what was going on. It was a sale contract that didn't get implemented or whatever, but they didn't have a rule. They were either going to go to court and get a rule from the court, or they're going to go to a mufti and get a rule from the mufti. But it's that movement from a mas'ala to a rule that interests me in the first place. And there's a very important instance of that in the case of these choices, the ikhtiyarat of the imams. This is the ikhtiyarat of Imam Ahmed from 1950s circa. And I'll just point out one very interesting one. The first one is about tasarrufat an-nisa, the transactions of women. Why am I getting that? Here we go. Tasarrufat an-nisa. It's all about fraud, deceit, intimidation of women by their own families. It says all their transactions are not legal if there's fear, etc. And so their transactions are not legal, except if there is no fraud, no fear, and it's established by the judge that none of those things happen, then they're valid. So this is protecting women's rights. This is an Islamic state, so to speak, protecting women's rights. Anyway, these are these kind of opinions, I would argue, are in the Fulan register. So it's the transactions of women. It's not a particular woman who's. But the origin of this kind of statement is in actual cases, trouble cases, difficult cases, where the judge, and I have this correspondence actually, the judge corresponds with the imam and says, we have this case before us, has some kind of features that we know, but has these other kind of issues like a divorce, a claim, or that has intimidation, or timidity by the wife, or other kinds of things. And so the imam is asked to give an opinion, which he does, but he gives it in framework of this case and those named people. So it's about an archival situation, a court situation, but it's later rendered in this kind of form, which is the Fulan form. It's generalized. And as such, it can be applicable to other cases. And I can show you that, in fact, such things happen. So here's a case in which there was a divorce rule that was applied in the actual case. This is you can't read this, but it does show you the form of the original judgment. But an earlier imamic choice, ikhtiyar, had been given about a problematic conflict, a divorce conflict, and how it should be settled, and what its conditions were. In other words, it was a mas'ala that was abstracted from an actual judgment, stripped of its judgment character, and stripped of its names, and generalized and made into an opinion, an ikhtiyar that could be applied elsewhere. And this was a case in which that same thing, 8 years later, that dated ikhtiyar was applied to an actual case. I think that, and this is just an aside on the khat in the cases, some of it's so beautiful. This is the basmala just on an ordinary hukum. And then this is the opening part, the Mahkamat Shari'a, Liu Ib, the province of Ib, this town. And this is the beginning of the judgment in which there is an application of an imamic rule. And this becomes part of even the judges' appointment letters when they were appointed. They were meant to rule according to the Zaydi school, madhab, but also according to any relevant choices of the imams. And they didn't cover everything. There's only maybe up to 20 different opinions of the imams that were used in court. I didn't mention one key technique that I learned from Wael Halak in these matters of moving across genres, moving from the archive to the library. It's about genre transformation, and the mas'ala is crucial to it, because the mas'ala can be something with named people, or it can be something that's fulan. And so and Wael Halak talked about in the case of fatwas, that fatwas were stripped and then appeared as part of a mas'ala, which is a literary form, in a law book. And he talks about a fatwa being stripped of it, the identification of the mufti, the notion it was a fatwa, stripped down to the mas'ala, the fact and rule situation, that could then appear in the fiqh, in the doctrine, as an opinion, maybe not even attributed to a mufti. And I say something similar happens in these choices, that the court situation and the people that were involved in the actual stimulus case, the one that was the problem, is all stripped away, and you end up with a piece of doctrine which is about a mas'ala, which is about a fact and rule situation. So anyway, maybe I'll leave it at that. Thank you very much. Did I not have the English slideshow?
Yeah.
I meant to put up the images of the book, but I forgot.
Okay. Well, the floor is open for questions and comments, and we use microphones because we have listeners online. So wait until you get the microphone before you put the question, please.
I want to go first, but I enjoyed that enormously, and I found so many parts of it extremely interesting. Can I ask one sort of factual sort of question, and then more theoretical question? The first one is, your period ends before print, I guess.
No.
No.
Did you see there was a printed commentary on the Kitab al-Azhar, on the Book of Flowers?
Okay.
I showed you a picture from the chapter on sale. Anyway, in the calligraphic state, I wrote a lot about print, actually.
Yeah, no, I realized. So I'm wondering if, okay, and for this, I guess, the use of the library and the archive, is that it all dependent upon the technology of writing versus print? I guess is a bit of a question. My other question is, if I can just ask both, is relating to the choice of the terms archive and library, because of course one hears the term archive and one immediately thinks of memory studies and Allied Osman, etc. And I think you're using it in a quite different way.
I am.
And I'm wondering also about Chartier maybe and D.F. Mackenzie and the sociology of the text in that field, because I think your work intersects a lot. So maybe just on a theoretical level.
Yeah, no, and first of all, memory is crucial, and it's something that actually the jurists talk about. So that one of the basic principles in that in the things about the discussions, the argumentation about al-amal bil-khat, the practice with writing and doctrine, is the question of memory. The basic rule is the judge should not judge a case based on a document if he does not remember. And so memory trumps the written text. But people argue about that. Even some Hanafis, Abu Yusuf and others, said things like they disagreed with Abu Hanifa on that particular subject. They said, if there are other circumstances of the archive being secure, not being sort of disseminated or lost or not knowing where it came from. It was in the judge's hands, for example. In some cases like that, a judgment or a text, an evidential text, could be accepted as a basis, an evidential base for a ruling. And there's many more things about that. In the case of people worry, judges and jurists worry about the death of witnesses and the death of writers. And their general solution for an instrument that was in any way problematic was to have the writer come in and have him dictate to the witnesses the text, and then have the witnesses swear to the evidence value of the text. That was the ideal form. I saw in the court records, it wasn't quite as complex as that, and it was rare because most documents were entered and not challenged. But when the document was challenged, the writer would be summoned and the witness would be summoned. You have examples of that in the cases. But the more normal thing is an old case that all you have left is that document. The writer's deceased and the witness is all deceased. What do you do then? And the jurists go on and think about those kind of things because they think about lots of things. And that's why it's interesting to do this work. Actually, they have amazing imagination. They say, is there possession on the part of the defendant? I mean, if there's possession by one of the two sides, then the case might go forward. If there's no possession, if it's contested purely and nobody has absolute possession, the zahir, the apparent situation is a non-possession, then the document really can't be used as evidence because it's too weak by itself. Chartier, all those folks. I mean, one of the things I do early on in this introduction is I say that a nascent anthropology of the text and of reading will have to depend and learn on bibliography, diplomatics, philology, codicology, paleography. I mean, there's an incredible number of disciplines of the text that and I share some of one of the things I share with most of them is I work in this book only on form, not on content. So I've left the content for the actual arguments, the property cases, the family structures, all that, and even their evidential structure. I work on it a little bit in terms of how texts are built. Court records are built by decision making by the judge and by the katib, the writer, about what to quote. But that's all for the future. But we have nothing but things to benefit from all the. And I have a colleague who writes about critical philology, which in fact also brings the reader's politics into the story. And we know from Edward Said that the whole critique of Orientalism was very much based on an Orientalist philology, which we have to be conscious of what that was before we can operate in a more wholesome fashion. Thanks.
Yeah, I was very interested in what you said about the anthropologist as a reader, and you specifically mentioned Talal Asad as a pioneer of this type of anthropology. My question is for you: is just where would you put Lawrence Rosen? I mean, in this genealogy of anthropologists, especially, I mean, there is something very unique about Lawrence Rosen, in the fact that he's also like a lawyer, meaning he has a specific type of, legal knowledge from another culture. And they said that it's because they had heard Larry Rosen make the argument that in order to be a legal anthropologist, you first need to be a lawyer. So I just would like you to comment.
I must not be a legal anthropologist. In fact, I'm happy that I wasn't trained as a lawyer. I mean, I'm curious about law, but that legal doctrine in Anglo-American law is so forceful, so hegemonic. It's hard to get out from under it. I'm sort of happy. I'm happy to have read fiqh and court records and instruments in a naive fashion, in an untutored fashion. In other words, without many kinds of preconceptions. Lawrence Rosen is not a reader. He was on my committee. And that was long before I became a reader in a conscious kind of way. But he absolutely is not a reader. There are no archives involved, hardly ever a case, and no doctrine except what he reads in Jacques Berck and others in the colonial apparatus. No, but in fact, he says, as you well know, and he's quoted all over the place, by Ottomanists and others, that the only thing that the judge does is turn people back around to settle their disputes outside the courts. He understands their predicament and they settle it. It's all about settlements. There's no evidence, there's no litigation, there's no claim, there's no judgment. And there are no court records either. So, and there's the doctrine, so he's not a reader. He's absolutely the foil for that older anthropologist. I appreciate him very much, but he's not a model for a study of the Sharia in my view. Also because the courts, he spoke of these courts which were a small appendage. The Sharia court was a small appendage to a French civil and criminal legal system in Morocco. And yet he spoke of that little appendage, which is only on marriage and personal status, as a typical Islamic court. That's not paying attention to the court as an instance of Sharia. I don't mean to be disrespectful to Lawrence Williams.
Well, many thanks, not just for the presentation, but for the book, because it's a real gem. My question actually starts from this. It's not on. From this last slide, right? Because it begins as al-Mahkama Shari'a. Out of my own ignorance about the Yemeni context, is that because there was a mahkama that was, for instance, Nizamiya? And if that is the case, isn't that also pointing us to the fact that these texts are also speaking to other forms of text, other kinds of courts? And if that is the case, why did you decide to stop there? And then, I mean, I understand that your framing of your timeline is about elements of the polity, that is the property structure and also the political outline. So if we were to move beyond 1962, then what other areas should be included in this? And then very briefly, I mean, it's not very brief, but do you think that this study is replicable in other contexts, or is it just that, I mean, the specificity of the availability of the archive and the library in the context of it almost unique? And
it's pretty unique.
Yeah.
On her blurb on the back of the book, on her blurb on the back of the book, Martha Mundy, my colleague, says there cannot be another like it. That's the last sentence, which I think is a little ominous. So on one hand, in other words, it'll have no impact at all. Or that the circumstances are so unusual that it would be hard to do something like that. And so two things. You point to the two frames, the two sides of the project, which is the Ottoman situation and the nation-state situation. So the nation-state, I don't go after 62 because I don't want to do nation-states. I don't want to do the notion of citizen. I don't want to do constitution. I don't want to do legislation, taqneen, tashri'at, all that. Police, lawyers, everything that comes and narrowing in certain kinds of ways. And so Sharia, the calligraphic state does try to do a little bit of that. But the Ottoman case is more problematic in terms of its impact. But the key feature you pointed out at the beginning is the Nizamiya courts. These are the new style courts introduced in the Ottoman Empire in the late 19th century and introduced across the Ottoman Empire. And the Sharia courts in that moment were basically reduced to personal status. And also you had the rise of prosecution, you had the rise of new kinds of lawyers. And the important point for me and for this case, for this instance, is that the Nizamiya courts were introduced in Yemen and abolished in about a year. In other words, they didn't stick. The Yemenis had some knowledge of what that was going on, but it reverted almost immediately to Mahkama Sharia faqat. That was all there was. The Ottomans did study, one of the things that did make an impact was the Majalla, the Ottoman codification. But we didn't know how it impacted. This was the first code, really. Maybe Qadri Pasha in Egypt was another kind of instance of codification of Sharia text, of doctrine. But in Yemen, it would seem to have no impact. Although I have some text from the Imam of the period of the 1920s, who instructed his Sharia court, his Supreme Court justices, to read the Majalla, read a few paragraphs from it every day, and convert it to the Zaydi madhab, but to produce something that would look like a code. And we don't know if they ever did that because we don't have that. But there was a code, provisional code made in the 1950s under the next imam. But so this is not, I'm not maintaining that this is an ideal Islamic world or a Sharia court. I am saying it's an instance. And I think it's an instructive instance in many ways because of the property regime, because of the kind of polity, because of the kind of jurisdictional range that, and because of the existence of the old madrasa system, because of the existence of single judges, with the lack of a prosecutor system, the lack of lawyers, the lack of police. So you had a more interesting set of circumstances for the thinking about the Sharia and history. And that's what I was interested in.
Hi, my name is Nido. Thank you very much for the presentation. Most of your work is about texts, and you mentioned that memorization of this text is very important. I was wondering if you encountered any oral tradition, and was the authority of that oral ruling or oral tradition, like what was the level of authority? Was it like the same as the rulings that were put in text, or was there any oral tradition that existed that was not put in text?
Very interesting question, and the answer is yes. I mean, one of the things I try to do is I both present this the Amal bil Khat as a very complicated juridical dilemma that is thought about in many ways, and in addition to the talking about it and the role of memory in it, and many other situations, many other factors. There's a whole chapter in the book on this question of al-amal bil Khat, and then some other chapters that reflect some of the subsequent problems about it. But in the archive section, a countervailing kind of set of material appears in some of the court records. This is the one time I speak in more substantive content terms, because in the court records there is disputation, and there are witnesses who testify against other witnesses. And one of the things you find is a kind of substratum of ordinary common sense assumptions about writing and about forgery and about falsification. And so I get into a very interesting discussion, I think, a detailed discussion of using this kind of lies, basically false testimonies, but it's all about saying the judge doesn't know the proverb of the Arabs that he who sins lies. Or they would cite hadiths that are sort of made up, or they'd accuse people of corruption, writers of corruption, or they'd pose writers as having admitted to falsification. So there's a whole substratum in the archive. This is written, but it's oral testimony, basically. So it's an access to what used to be the old anthropology, which was commonsensical understandings. That's what Geert said anthropology was about. It was about commonsensical understandings. So that, yes, there's much more to be done. And when I read, I'm working now on litigation more. And to think about litigation is to think about the kind of critiques of the process itself that's in the court records. Very interesting. This is oral origins kind of material.
Oh, cheers. Hello. Since we're at the Institute of Somali Studies, I wonder if during your fieldwork in the 70s or their most recent trip, if you ever came across the Suleimani Somali communities in Haraz and Najran, and if you did, did they have some sort of kind of navigation like the Zaidi community with the Shafi law and the Itiyarat, and the Imam, and just...
Najran was out of the range because it was in Saudi Arabia. Yes. And in Haraz, there was a very important community, as you know, and there was a Swedish anthropologist, Thomas Gerholm, who worked in Haraz and worked and wrote a bit about this Mali community that he studied in Manakha. And in my neighborhood, which is in the south, and first of all, the history between the Zaidis and Ismailis is very bloody, and what the Ismailis had moments of ascendancy. When you had imams of the Zaidi party confined to the north, you had a very famous political leader in the south, in Arwa Salehi, this is Fatimid period stuff, but in the town right across the valley from it, Jibla, there are, her tomb is there. In a large mosque she's said to have built. And there was sort of problems about her tomb's location near the mihrab of the direction of prayer, so to speak, and whether the people praying would be praying towards her or not. Anyway, but her presence there is amazingly significant, I think, even for present day history. I mean, I knew lots of young girls, and I didn't know the women, I knew the girls, some of them, who were named Arwa, or either named Arwa or Bilqis, Sheba. And we've seen in the Arab Spring the incredible power of women who led the Arab Spring in Yemen on Tahrir Square, Tawakkul Karman and others. So there's work to be done. The Jibla story of the Ismaili community in the neighborhood of Jibla, the tomb of Arwa, who was Fatimid era, Sulayhi ruler, feminine ruler, and then the northern history has been written a little bit. But I just had a student in my own seminar this last week who I noticed he came in to talk about a paper he was going to write for the seminar, and he had Ismaili law books. He had the basic ones that are published. And so there's a great future there.
Thank you, Professor. I really enjoyed that. I've just got a question considering just the point about oral tradition earlier. You talked about sort of a theory of native, and I was wondering whether you would include oral tradition within native theory.
Yes, I mean, one of the methods, the basic methods I used was to read with people. When you read with people, it's an oral exchange over the text. And it's an oral sort of annotation or sort of indication in the text. A person would say to me, look how this prose is rhymed. You know, I might not have paid attention, and that person would say, we don't do this anymore. This is the transition, shajat. It was something that the old notaries used to do to sort of embellish the text, for example. The question of orality is very large. I didn't get into it very much, but one wants to consider the Quran and the Sunnah as both oral originally. And so you have a huge transition from the oral to the written in both cases. In both cases, there were controversies, especially with hadith. The writing down of hadith is a huge controversy. That knowledge is in written form is suspect, and only the oral is authentic. And then in the whole madrasa culture, you have imla, you have again dictation of the lesson. You know, why does the book have to be dictated? Because there's authority in that. And what's happening with that dictation? The students are writing it down. And is it being dictated from memory, or is it being dictated from a text? Orality is important, it's crucial. And it's, again, I mentioned the courts, the oral testimony being recorded and then recited back. The judge, before he reads his judgment, will dictate it. Again, imla, same kind of term. Orality is everywhere, at every juncture, at every synapse in the tradition. But the important question for me is, if you have the two foundational texts having originally oral form and the Quran retaining an oral recitational form, what is the impact of those authoritative usul on the rest of the textual formation?
There are two more people on the list, and I think that will be enough. You know that you're all invited to a reception afterwards, so you have the opportunity to speak to Professor Messick at the reception. So please.
Just a small question. Were there appeals to a senior court, to the Imam's court? Because that's a whole can of worms.
And it's also a modern can of worms. It's not about the Sharia and history. There were no appeals.
It is in northern Nigeria. Pre-colonial courts always had an appeal to the caliph.
I'll have to look into that.
The Madhalim.
Well,
The Madhalim.
Madhalim is a different story.
Yeah.
Madhalim is the story of petitions and a court. Madhalim is in the Mamluk era, very important. And it was important in Yemen too. This is a kind of a place where you had shakawa, you had petitions and claims which could cover everything from my salary is missing, I want to move, I need a position, or to something that might have Sharia litigation implications. And Madhalim has been projected as the foil of Sharia in some cases, as a kind of ruler's tribunal. In Yemen, I think you see how it another way, because the Mazalim was just simply a part of another channel for ordinary kind of petitions. Some of them had implications for courts, and those who read the petitions, and I've collected those petitions actually a lot, and they would be transferred to a judge in a few cases. Or there may be an investigation if there was corruption on the part of the judge, you might find it that way. But Mazalim is a and it's an important thing is being worked on these days. But again, we have to deal in instances. And the Mamluk era is an instance in which the Mazalim kind of tribunal, if you might want to call it that, was very important. Other times it wasn't so important. But this appeal thing is not a part of, except for maybe northern Nigeria's example of pre-colonial. I'd like to check into it. Shakt actually wrote about Nigeria and wrote about the Maliki madhab there in very interesting ways. But I think of the appeal court as a new kind of phenomenon. And it changes the thing. It changes the way a judgment is written. Because it may be the case that a judgment is more explicit about certain things, about the evidential base for the decision, if there's going to be another reader, in other words, an appeal court. And the appeal court, though, in this case, has a certain number of justices. It's a joint, it's not a single judge anymore, which is very unlike the Shari'a system, which is always a single judge. And then you have the possibility of appeal. And you know, some of these documents of appeal are totally fascinating because they are a review of the judgment itself. It's another reading. It's like a commentary on the court decision by the person who lost and maybe by the person who won to support their case. And then, but the final decision usually is the imam who authenticates the Supreme Court ruling. We saw that his diwan giving an authentication for the appeal ruling. But I think it's more in the Yemeni case. It's not really a full-blown Ottoman system, even though they had it in Yemen until 1918, and there were Yemeni judges on it. Later, it became focused in the imam. But it's very important, this appeal thing.
In reference to my friend's question about the Zaidi and Ismailis, were the Ismailis Hafizi or Tabis, or were they, and I'm also going to know Zaidi Imams, are they coming from Zaidis from Imam Zain al-Abidin, the ancestry, or can you explain, please?
Yeah, they're Shi'i of Zayd bin Ali, who was a grandson of Ali, Imam Ali, and there's that tradition. And Hassan Hussein, the branching and the numbers, the 12ers, the 7ers, the 5ers in the Shi'i world, it's pretty clear. They are Shi'i, but they're the Shi'i group that's closest to the Sunnis. The most amazing thing to me when I read their jurisprudence is the non-citation of either 12ers or Ismailis. Their interlocutors were not other Shi'is. Their interlocutors are always the Sunnis, Shafi'i, Ibn Hamda, etc., in detail. In fact, they have rumuz in their text, these abbreviations. It's very standard in fiqh text. They have abbreviations, and half of their abbreviations are to people like SH, Shafi'i, because they're cited so often that you need abbreviations for them.
Ismailis, whether Hafizi or Tabis.
Yes, right, okay. So again, Najran in that story, I met a Saudi young man not too long ago who said, I grew up in Saudi Arabia and I was 15 years old before I knew I was Ismaili. Which is an amazing statement. Because his father turned out to be the head of the community. And the kind of non-transmission that was going on there, it was new to me. And he didn't even know what to think with it. How to think about that position. And who is this? Anyway, I don't even want to interpret it or make any statements about it. In Yemen, I don't know the madhab differences among the Ismailis, which obviously are there. But the folks who come to Jibla to visit Queen Arwa are Bohra. And so that's as much as I know, basically. I know that there are Ismaili villages and there's history, and there's the Sulehi, there's a guy named, what's his name? There's a book on Sulehi Hun in Arabic that's about that dynasty and Arwa and her father and her husband and the Fatimids. That's a very important source. That's one of our most important sources for the Ismailis in Yemen. I can give you that reference if you like.
Okay, thank you so very much. So, no, wait a second. Before we end this, I again repeat, you're all welcome to a small reception outside. And I also want to get applaud for Professor Brinkley that we include the staff who have helped out and organized both the reception and the possibility to listen and see the lecture on the web. So, thank you very much.
Yes.